If your employer terminates you and presents you with a severance agreement, there are several terms that can be negotiated or revised. First and foremost, the amount of money paid by the employer is almost always negotiable. Remember that the employer is paying you to release your legal claims, so the amount the employer is willing to pay in severance is often tied to the strength of any potential claim you might be releasing, as well as the potential damages you may be entitled to should you prevail in any future litigation. There are also other important provisions to consider before signing any severance agreement. Will the employer agree not to disparage you to third parties? Will it provide you with a positive reference to give to future potential employers? Will it agree to characterize your departure in a way that will not be harmful to you in your search for new employment? Now, by the same token, employers often include additional terms that place obligations on the departing employee after the severance agreement is signed. For example, it may require you to protect confidential company information and trade secrets, or it may require the employee to provide reasonable cooperation in transitioning out of the company, or with respect to future litigation or regulatory investigations about which the employee has relevant knowledge. There are various ways of enforcing these provisions, including with the use of what's known as liquidated damages provisions. These provisions call for the employee to pay specified amounts if they are found in breach of the severance agreement's terms. Employees should be very wary of entering into agreements that contain overly restrictive provisions or apply harsh penalties in the event of violations. They should not simply accept whatever terms the employer first proposes, as there is often room for negotiations.